Every invention we use, every book we read, every logo we recognize, all are protected by something called intellectual property rights. But these rights did not appear suddenly. They evolved slowly, shaped by trade, technology, creativity, and law. Intellectual property rights, commonly known as IPRs, are legal rights granted to individuals or organizations over their intellectual creations. These creations may include inventions, literary work, artistic expressions, symbols, designs, or confidential business information. The objective of IPR is to encourage innovation and creativity while also ensuring that society ultimately benefits through public access after the expiry of. I will discuss the historical evolution of various intellectual property rights, including patents, copyrights, trademark, designs, geographical indication, and plant variety rights. The origin of IPR can be traced back to the ancient civilization. Artisans in Rome, China, and India used distinct marks on goods to indicate origin and quality. During medieval times, rurals granted exclusive privileges to craftsmen and traders. However, these rights were royal favors rather than legal rights. Over time, this system evolved into a formal legal protection, replacing arbitrary monopolies with structured laws. Patents are amongst the oldest and most significant forms of intellectual property rights. They exist to protect the new invention, processes, and technologies, encouraging innovation by granting inventors exclusive rights for a limited period. The roots of patent protection can be traced back to the ancient times, as early as the 500 BCE in the Greek city of Cerberus. Chefs were granted monopoly rights over newly created dishes for 1 year, marking one of the earliest recognition of innovation-based exclusivity. Moving to the medieval period, in 1469, the Republic of Venice granted a 5-year monopoly to John Speyer for the invention of the printing press. This marked a significant shift towards a formal recognition of technological innovation. This idea was codified in 1474 through the Vatican Statute, widely recognized as the world's first patent law. It granted inventors exclusive rights over their new inventions for 10 years in exchange for public disclosure, an essential principle that continues to define patent law today. In 1624, England enacted the Statute of Monopolies, the first comprehensive patent legislation in the UK. It provided 14 years of protection for new inventions and laid the foundation for modern patent system worldwide. This statute is often referred as the mother of all patent legislations. Of protection of patent law reached India during the colonial period. Through the Act 6 of 1856, the first patent law in India was introduced by George Alfred D. Penning. The objective was to protect new and useful manufacturers, and rights were granted, described as exclusive privileges. This act was later amended in 1859. Notably, the first patent in India was granted in 1856 to George Alfred D. Penning for his invention, the efficient pankha pulling machine. Finally, in 1872, the Patents and Design Protection Act was enacted, consolidating design protection within patent law, further strengthening the framework of intellectual property in India. In 1911, the Indian Patents and Designs Act was enacted, introducing the Controller of Patents as the governing authority and repealing all previous patent and design laws. Until then, Indian patent law had largely followed the UK model. After independence, reforms were initiated to align patent law with national priorities. In 1949, the Justice Bakshi Tek Chand Committee reviewed the existing system, and its recommendation led to amendments in 1950. This was followed by the Justice N. Rajagopala Iyer Nagar Committee in 1957, whose report in 1959 laid the foundation for a comprehensive patent regime. Based on these recommendations, the Patents Act 1970 was enacted, which continues to govern Indian patent law. At the international level, patent protection evolved through the Paris Convention of 1883 and later achieved global harmonization through the TRIPS Agreement of 1995, making patent protection mandatory for all WTO members. To comply with TRIPS, India introduced major amendments: the mailbox system in 1999, the extension of patent term to 20 years in 2000, and the recognition of product patents across all technologies in 2005, along with provisions for compulsory licensing and restrictions on evergreening of patents. Copyright protects original literary, artistic, musical, and dramatic works. Unlike patents, which protects inventions, copyright does not protect ideas, but it only protects the expression of ideas. The evolution of copyright is closely linked to the development of the printing technology. In 1439, the invention of the printing press by John Gutenberg marked the starting point of the copyright history, as mass reproduction of works became possible. In 16th century England, copyright protection emerged through the Stationers' Company, a guild of printers and booksellers. In 1556, the Crown granted a royal charter to Stationers' Company, giving them exclusive rights to register and publish books. Publication without registration was prohibited, and infringement led to destruction of copies and fines. At this stage, copyright was granted to booksellers and not to the authors. The focus shifted to authors with enactment of Statute of Anne. 1709, the first copyright legislation was introduced. It recognized authors as the owners of copyright and granted 14 years of protection, marking a major transformation from protecting just printers and booksellers to also protecting the authors. In 1911, the Imperial Copyright Act was enacted in the UK, consolidating and replacing nearly 20 existing copyright laws and providing a comprehensive copyright framework. Now, Now, talking about the evolution of copyright in India occurred in three phases. During the British era, the Copyright Act of 1843 made registration mandatory and provided protection for the life of author plus 7 years or 42 years, whichever was shorter. This was followed by the Indian Copyright Act 1914, which largely based on the Imperial Copyright Act of 1911. After independence, India enacted the Copyright Act 1957, which remains the governing law today. This act incorporated the principles of Berne Convention 1886 and was subsequently amended to comply with international agreements such as Rome Convention, WIPO Copyright Treaty, WCT, and WIPO Performance and Phonogram Treaty, WPPT. Through these amendments, rights relating to performance broadcasters and producers of phonograms were strengthened and the term protection was extended from 50 years to 60 years. Talking about the evolution of trademarks, trademarks protect symbols, names, logos, and slogans that distinguish goods and services in the marketplace. From ancient guile marks to modern brand logos, trademarks has evolved alongside with the growth of trade and commerce. In pre-independence India, there was no statutory protection for trademarks. Instead, trademark dispute was resolved through the common law remedy of passing off, which protected goodwill against misrepresentation. Relief under passing off depended largely on the judicial discretion, making enforcement uncertain. The first statutory protection for trademarks in India came with the Trademarks Act 1940, which was largely based on the UK Trademarks Act of 1938. This marked the beginning of formal trademark protection in India. Subsequently, the Trade and the Merchandise Marks Act 1958 was enacted. It provided a 7-year term protection and made registration mandatory. It strengthened enforcement by incorporating provisions from the Indian Penal Code, Criminal Procedure Code, and the Customs Act. In order to align with international standards under the TRIPS Agreement, India enacted the Trademarks Act 1999, which is the current governing law in India. This act extended the protection to 10 years and expanded trademarks protection to include service marks, collective marks, certification marks, and well-known marks. It also introduced the provisions allowing a single application to register a trademark in multiple classes, simplifying the registration process. Industrial design protection focuses on the visual appearance of products, including their shape, configuration, pattern, and ornamentation. With industrial revolution and the rise of mass production, protecting products' aesthetics became essential to prevent imitation and to encourage creativity in manufacturing. At the international level, the protection of industrial design was strengthened through the HOG system, which enables industrial registration of industrial designs, ensuring protection across multiple jurisdictions through a single application. Now, talking about the evolution in India, the earliest recognition of industrial design in India came with the Patent and Designs Act in 1872, where designs were protected under the broader concept of manufacture. This was replaced by the Invention and Designs Act 1888, which provided a more structured framework for design protection. Subsequently, the Indian Patents and Designs Act 1911 was enacted. This legislation introduced the post of Controller General for Patents and Designs and initially provided 5-year term for protection, which could be extended up to 15 years. The Act was clarified and the relationship between copyright and design protection, including their respective terms. The present law governing industrial designs in India is the Designs Act 2000, enacted to ensure compliance with the TRIPS Agreement. Under this act, design was protected for an initial period of 10 years and it can be extended to 5 additional years, making the total of 15 years. Geographical indication protect goods whose quality, reputation, and other characteristics are closely linked to their place of origin, such as Darjeeling tea or the Kolhapuri chappal. GI protection originated in Europe and later became the part of international trade law through TRIPS, which encouraged the protection of traditional and regional knowledge. Before this, India lacked any statutory framework for GI protection. Consequently, the Geographical Indication of Goods Registration and Protection Act 1999 was enacted. Under this act, protection is registration-based and granted a fixed term and renewable. Similar to trademarks, it safeguards goods originating from a specific locality that derive their value for geographical identity. Plant variety rights protect plant breeders who develop new plant varieties. Internationally, formal protection in agriculture began with the US Plant Patent Act of 1930, followed by the framework like the UPOV Convention. Under Article 27.3b of TRIPS Agreement, countries were allowed to adopt suitable systems for plant variety protection. In response, India enacted the Protection of Plant Varieties and Farmers' Rights Act in 2001, uniquely balancing breeders' rights with farmers' rights. The term protection is 9 years for the trees and vines and extendable to 18 years, and 6 years for other crops, again extendable for 15 years. Together, the evolution of these rights reflected how intellectual property law expanded beyond the realm. In conclusion, intellectual property rights have evolved from selective royal privileges into structural legal frameworks that govern modern creativity and innovation. As ideas travel faster than borders and technologies change rapidly, IPRs continue to adapt, ensuring that innovation is encouraged and not exploited. Ultimately, intellectual property right is not simply about ownership in law, it is about ensuring that ideas are respected, creativity is valued, and innovation is allowed to leave a lasting imprint on the world. Thank you.